Good afternoon, everyone. I welcome all the professional members of ICSI, the insolvency professionals registered with ICSI IPA, insolvency professionals registered with the sister insolvency professional agencies, all other professional members and stakeholders viewing this webinar today. This is the first webinar in a series of webinars which are proposed by ICSI Insolvency Professionals Agency on the Insolvency and Bankruptcy Code 2016. The effective implementation of any legislation requires advocacy. Towards this end, this is the knowledge initiative of the ICSI and the ICSI Insolvency Professionals Agency. The idea is to disseminate and create awareness and knowledge about the various legislative measures which are being taken by the Government of India. And as you all know, the Insolvency and Bankruptcy Code is a major legislative reform which has taken place after the independence of India, next only to GST. We have a very dynamic president, Mr. Shyam Agarwal, who could not make it today, although he was very much inclined to be here today. And his vision is that ICSI should join hands with the Government of India in advocacy of the various laws so that the professionals, the industry, bankers, investors, creditors, as well as the common man truly understand the impact of these legislative measures and also the benefit that they can draw out of them. Towards this end, ICSI is organizing a series of webinars on GST, Companies Act and the Insolvency and Bankruptcy Code, in respect of which we have made an announcement in the various newspapers. Today at this webinar, we have with us the Secretary ICSI, Mr. Dinesh Arora. We welcome you, sir. We also have Mr. Vineet Chaudhary, who is the council member of ICSI and a director on the governing board of ICSI IPA. He has closely worked with the various committees of the government constituted towards drafting of the IBC and the various regulations framed thereunder. We welcome you, Mr. Chaudhary. Our expert faculty today is Mr. Anil Goyal. He is a registered insolvency professional, chairman of AAA Insolvency Professionals LLP, which has been recognized by the Insolvency and Bankruptcy Board of India and is one of the first two entities which has been recognized by IBBI. He has more than 3 decades of experience as practicing chartered accountants as AKG and Company Chartered Accountants. Besides regular CA practice, he has been engaged in handling bank loan proposals, structuring and restructuring of debt and equity, nursing and rehabilitation of business units, takeovers, mergers, etc. He also has over 15 years of experience in handling more than 14,000 SARFAESI cases in his capacity as chairman of AAA Capital Services Private Limited, the India's largest resolution and enforcement agents under SARFAESI Act. We welcome you, Mr. Anil Goyal.
Thank you very much.
It's very interesting to see how the new law is taking shape. There are many cases which are being registered with the various benches of NCLT, and the government has a lot of expectations from this code. The major expectation is the statistics on ease of doing business. As you all know, as per the World Bank Doing Business Survey, India stood at 136th rank in the financial year 16-17. At present, it has managed to rise up to the level of 130th rank. The expectations from IBC and the other legislative measures is that India would rank at 90th position by 2017-18 and 30th by 2020. Of course, it's a daunting task, but not an impossible one. The code will ensure release of the second expectation from the code is that it will ensure release of substantial amount of capital which is currently locked up in the non-performing assets. The stressed assets in Indian banking system account for approximately 10 lakh crores. Yes, you heard it right, approximately 10 lakh crores. And these are proposed or expected to be released through the IBC. Friends, there is a paradigm shift from debtor in possession to creditor in control regime through the IBC. A most important feature of the code is that it offers a resolution plan, a resolution process, a survival plan, wherein the bankers, creditors, investors, corporates work in harmony to bring a resolution and revive the company. The liquidation, the dissolution or winding up of the company is only the last resort. Just for information, today, as of today, 260 cases have been filed with the various benches of NCLT, of which in respect of 28 cases, the insolvency professionals have been appointed, the 40 cases have been dismissed, and the amount of default which was involved in these cases is to the tune of rupees 5,000 crores. While the code is shaping up and the law is taking its place, there are various challenges which are being faced by the insolvency professionals and others involved with the implementation of the law. One of the major challenges before IPs is the taking over of management of the company by the insolvency professional. And a live example of this is Raipur Power and Steel Limited versus Tomorrow Sales Agency Private Limited. This case will be discussed in detail in the seminar today, in the webinar today. Coalition and verification of claims is another major challenge for the IP, as the number of creditors may be large. And a classical example of this is the case of Mr. Surendra Kumar versus REI Agro Limited, which I am sure you will discuss today, sir, wherein an employee filed a case for the release of his salary to the tune of rupees 1.2 lakhs. And what was revealed when the whole process was involved is a total debt of rupees 466 crores which was on the company. This also shows the efficacy of the code in bringing the fraud to light. Friends, another challenge, the other challenges which IPs are facing are so many which I would not deal with, but the professionals today will deal with them here, and these include meeting the timelines, valuation of assets, indemnity and insurance of IPs, etc. But we all know, any new legislation, there are implementation issues. But with the positive attitude and a will to make the difference, these will be overcome. There are a lot of expectations from the from the Insolvency and Bankruptcy Code, and much of its success would depend upon how its 4 pillars, which are the courts, the NCLT and the NCLAT, the insolvency professional agencies, the information utilities, which are going to be constituted shortly, and the insolvency professionals, how they would function. Since the code is a new area, everyone will surely develop expertise over a period of time. But one thing is for sure, and this is also a message from our president, Mr. Shyam Agarwal, is that IPs should be very cautious about maintaining their integrity in all their assignments. As they would be virtually taking over the managements of the company, they need to remember that they represent all the stakeholders, and therefore they should be totally ethical and transparent in their dealings. Friends, the Insolvency and Bankruptcy Code, the law, is here to stay, and we will surely meet the challenges and see a new era in business, the banking sector, which will take the country a leap forward. With this, I now request our Secretary, Mr. Dinesh Arora, to kindly share his views on the new law.
Good afternoon to all the members and the IPs and all the other participants. On behalf of the Institute, while extending this opening remark, I would like to add a couple of points here. When the expert speakers are here, including Anilji, who will speak more on this, as a part of the series of reforms taken, this very important reform was taken by the government, which takes the matter of specialization by doing this tribunalization process, wherein the two-layer legislation platforms have been created. One in terms of the limited liability part, which comprises the corporates and the LLPs. For that, the platform is NCLT, and the other platform is the unlimited liability part, which is mainly the proprietorship and the partnership form, and the legislative platform for that is the DRT, the Debt Recovery Tribunal. This has been done mainly with the intent to achieve the objective of the ease of doing business. We all know that how long these cases have been hanged over a period of time, and the disposal takes a lot of time, effort, energy, and sometimes it is never ending. The beauty of this process, this reforms, is that there is a time limit, and that too a fairly aggressive time limit. Within 180 days, the case has to be disposed of. Though in certain cases it can be extended for another 90 days. So I believe that within a total span of 270 days, the case has to be disposed of. And this is what actually the real intent is. And creating a separate tribunal platform is that it should not go to various courts one after the other. It should straight away go to the tribunal, the specific tribunal, and within a time frame, it should get disposed of. This is what the intent is. And I'm pretty sure that when these reforms were taken, when this modality was developed, a meticulous approach was taken, as a result of which we have a very beautiful system now in process. Though in the coming days, many things will be unfolded, which even we are not aware of, or we also cannot predict how the things will shape up over a period of time. But one thing is certain and sure, that this is one thing which will take the economy and the whole process of doing business in India will go to the next level. Thank you so much. I invite Vinayji to extend further his views on that, and thereafter Anilji will speak on that. Welcome, sir.
Thank you, Raji. Friends, a very good afternoon to all of you. As you all know, this Insolvency and Bankruptcy Code 2016 is one of the most debated and you can say the game changer legislation after the GST. In the last 2 years, we have seen a lot of corporate reforms have taken place. Number of legislations have been amended or deleted from the books itself. As Alkaji rightly observed, the expectation of the every stakeholders, whosoever is looking at the IBC, is to get a lot of capital out of the distressed assets, unlock the capitals. Rightly observed by Aroraji also, that specialization of the tribunals is expected to deliver the judgment in a more commercial term. They can understand the commercial issues, specialization, as well as the disposal well within the time. I think the IBC is the complete foundation is depend on the disposal of the cases on the well within the time, and that is the limitations of the time is the crucial factor. When today we are here, I must compliment ICSI IPA for taking this initiative, being a part of ICSI IPA. In fact, it's my pleasure that today we are starting this initiative, that we will be coming to you through various webinars. We are also planning to come out with certain physical workshops in which we can discuss one-to-one with our IPs, that what kind of the issues are coming. Definitely when some legislations comes into picture, it has to have certain challenges. That's same the case with the IBC also. Friends, let me be honest, having been the part of the various committees in drafting of the various rules and regulations framed under the IBC code, and thereafter acting as professional advisor to many of the the insolvency proceedings, including in the tribunals, I can assure you this is really a very, very interesting code. But the few things have to evolve over a period of time are evolving. Like the madam highlighted the issues relating to the IP's difficulties to take over the management, which is the primary duty, even to open the bank account and how to carry on the business, because you have to carry on the business on ongoing concern basis. This is your responsibility as an IP to add the value to the system and to act honestly and diligently in accordance with the provisions of IBC code and regulations made thereunder. I am sure Anil ji is going to discuss the detailed procedure envisaged under the code as well as the CIRP regulations for the insolvency proceedings so far as the corporate insolvency is concerned. I am sure in time to come and very soon, I am also the part as I highlighted, the government is coming very soon on the individual insolvency front also, and will see a different regime for the insolvency resolution in the country. I am sure Anil ji, you will take the practical queries and issues also, whatever being faced by the limited IPs who are dealing with the matter. 250 cases, almost 260 cases being filed, few are going on. Even the tribunals have, as observed by Arora ji, has given their focus to these matters nowadays. Very interesting discussions are coming on financial, on the definition part itself. Few matters are under the considerations at the different benches. Few are coming to the NCLAT as well. So it would be interesting to take note of in time to come what kind of the decisions comes, and we have to keep our eyes open. We have to learn all these things by which we can do our duty diligently. We can advise the client, and actually we can become the part of the building India. That is something what we are supposed to do as an IP, not only to act as a professional for some remuneration. So that will definitely follow. So towards the capacity building, this is a great initiative. Will be coming out certain publications also very soon. Electronic platform we are trying to build up and develop. My compliment to the IPAs of the ICSI, particularly the company secretaries. I am very happy to take the data on record. The way the examination conducted under the code through IBBI has been passed by our members. They are doing wonderful job. At ICSI, our team led by Madam Alka Arora from time to time is sending various informations to our members. Not only to the members, my compliment, and as our vision that we have to take it to the larger scale. The ICSI IPA is open for every kind of the professional, be it chartered accountant, advocate, be it anybody. So we are also disseminating all those information to everyone equally. We are treating on par. Even this webinar is open to everyone who can join. We look forward your kind support, your all inputs all the time to improve our working, to make it more fair and transparent, by which we can build up the capacity of our all IPs who are associated with the institute. I wish this program, this webinar is going to be a grand success. I am sure the questions and the deliberations taking place will help the other participant to understand the various nitty-gritties and the questions involved in the subject matter. In time to come, we will find and we will take it to the different kind of the programs also. Thank you very much, Alka ji, for inviting and giving this opportunity. Because we have also another meeting, so me and Arora ji probably has to join with the NSPCG meeting. Please continue with the subject. Thank you very much.
Thank you so much for joining and coming.
Thank you very much.
Please
Thank you very much.
Welcome, sir.
Thank you for sharing here.
Good afternoon, everyone. I take this opportunity to compliment Institute of Company Secretaries, led by its president, Shyam Agarwal, secretary, Mr. Daresh Arora, and the council members. And we had, as including Mr. Vineet Chaudhary, who is the chairman of Corporate Law and Governance Committee of the ICSI. I also compliment the efforts made by IPA of ICSI, led by Mrs. Alka Kapoor. I also understand that they have been working on various programs for spreading awareness of the Insolvency and Bankruptcy Code, and also imparting education. They have also brought some books. They have taken out some books. They have compiled certain data, and they are also in the process of making some brochures and other education material. See, we would this session will actually have some, it will continue till 5 o'clock. In between, we will be taking questions on a gap of about 20-30 minutes. And I would request everyone, every participant, that more the questions, it would be very, very interesting to have this webinar. One question from one person and the answer goes to all the participants. So please do ask questions. We will try our best to handle the questions. Till now, most of the participants, which I guess would be professionally qualified company secretaries, lawyers, chartered accountants, bankers, and businessmen. So, see, as far as this objective of the code is concerned, I believe most of the participants must have known by now, because this code was notified in May 2016, and it was the corporate insolvency resolution process was notified on 1st of November 2016. So from 1st of November 2016, it is already 5 months, and in 5 months, as Alkaji has said, you can understand the excitement in the industry that 250 applications have been filed for initiating corporate insolvency resolution process of corporate debtors. This is an evidence of how the country has accepted this law. So, like, if we understand the reason why this law was required, so we need to understand the background in this country regarding solvency of regarding handling insolvency of companies, insolvency of non-incorporated entities. So because there was various forums which was handling various courts, various boards, tribunals were set up in the past 30 years for handling the insolvency and bankruptcy of individuals and corporate debtors. So before this Insolvency and Bankruptcy Code, the legal and institutional framework was also spread, and it had actually not delivered much, including BIFR. DRT also had its own difficulties, and the CDR mechanism also could not deliver much. SDR also could not deliver much because of the authority and lack of willingness to participate. But this law, in fact, when this Bankruptcy Law Reform Committee was constituted in November 2014, this committee also did a wonderful job. Within 1 year, it came out with a report, and within couple of another months, even the Joint Committee of Parliament, they came out with the modification, and finally this code was notified on 28th May 2016. See, the speed on which it has been done in this country, that is also unprecedented. And even in case we understand the post 28th May 2016 scenario, the board was constituted, all the recruitments were done, the regulations were made, and on 1st of November it was notified, and on the in the very next 2 days, the 3 IPAs were formed. It shows that the preparations were done much before that. Within 3 days of notification, IPA of Institute of Chartered Accountants of India, IPA of Institute of Company Secretaries of India, and IPA of Institute of Cost and Management Accountants of India were formed. Not so much, even the insolvency professionals were registered within another 2 days. The enrollment process started within the next 2 days, and the certificates of enrollment was handed over by Honorable Finance Minister within 2 days of formation of IPAs and within 5 days of notification of this code and regulations. This probably would be considered as a historical reform in this country. While so far the things have been done in a very, very careful manner, in a very, very efficient manner, under the guidance and leadership of Dr. M.S. Sahu, who is the chairman of Insolvency and Bankruptcy Board of India, the regulator in this case, the regulator for all the IPAs, the regulator for all the insolvency professionals, and also responsible for implementation of this law in the country. See, in the past, what we have seen, most of the bankers, most of the professionals, they have seen that in India, the recovery process was very slow, and it was taking 3 and 4 times of the average time which has been taken internationally. So the India was much behind in recovering its NPAs. Secondly, India was losing investor confidence. The international investors, they were asking for this kind of law because they wanted to have ease of doing business in India. So this was also one of the major requirements, that we wanted to be better ranked in the world as far as ease of doing business in India is concerned. See, most of the law like BIFR or even SARFAESI, it has also suffered because of various interventions from various courts, various kinds of stay by different authorities in this country, which has actually made the process very, very slow. So in the process, what had happened is that the control and possession of the assets of the corporate continued with the debtor, continued with the shareholders. So this is the biggest change in this code, that the debtor in possession now has been changed to creditor in possession. In fact, there was a recent judgment by Justice Prakash Kumar in the case of Uttam Galwa Steel, and he has actually said in that order that I have seen that the shareholders have already lost their money by way of losses, and the company is presently running on the investment on the funds by the creditors. So what is wrong in case the creditor have the control on the company, and why should the shareholders have the control on the company? Because they have already lost their money. The money which is presently being used for running the company it belongs to the creditors. So these kind of judgments actually would encourage the entire fraternity, and these kind of judgments, in fact there are many other small questions which have been handled by this judgment, and I compliment that the judgment is absolutely changing this scenario. See, this Insolvency and Bankruptcy Code actually would be very, very effective in identifying the sickness at an early stage, and it also would initiate the process very, very quickly. See, when we had SARFAESI Act in 2002, we tried that the control and possession should be handed over to creditors in a very, very simpler manner. But there were some deficiencies which came out during the process of implementation of SARFAESI Act. Like it was time consuming. First of all, no action under SARFAESI was possible unless the account is classified as NPA. Secondly, even after the account is classified as NPA, it was a separate decision by the banks to invoke the provisions of SARFAESI Act. After the bank decides to invoke the provisions of SARFAESI Act, it was required to give it 60 days notice. Then thereafter, the procedures for taking over possession, approval of the local authorities, police help. See, on an average, with full efficiency, it used to take about a year's time when the creditor used to take control of the assets. So this 1 year actually was enough to kill the business, and also it was enough for the promoters, for the borrowers to siphon off, to steal, and to misutilize the funds and fund flow of the company. So this was also a kind of reason that something required which actually can identify and also acted upon quickly. So this particular code also creates a platform where all the stakeholders can sit together and decide in the form of a resolution plan. The creditors can take power. The creditors will actually understand the business model. In case they are comfortable with the business model, they will actually make sure that the company continues, the operation continues, and they will provide a solution to the borrowers, to the corporates. See, there are a couple of things that I would like to say, that why this particular process would actually be a fast track. Although it is said that it would be a fast track, but there are reasons that it would be a fast track. There are reasons that I believe that it actually would continue to be a fast track resolution. The reason number one, it's like any delay or any inertia on account of maybe by stakeholders or by lenders or by borrowers or by creditors would lead to liquidation, and liquidation is always a inferior economic value. Historically, during liquidation you don't recover as much as you can recover through cash accruals. The liquidation value of the company is always lower unless it is already closed its operation or unless the business model is not viable now. That is a separate scenario. Then those kind of companies should actually be liquidated as fast as possible, so they should not misuse their platform of a company and borrow further or cheat further. See, this particular code, in case we start a resolution process in the case of a company, most of the investors will have confidence. They can come forward and provide additional funding for the requirement of the business by modification of the charges, by having a priority charge. So this is also one of the reasons which was not earlier existing. And then the third is like the moratorium clause is very, very effective. There are penal provisions. In any case, anyone violates moratorium provisions of IBC, there is a fine combined with imprisonment, and it is not restricted to the borrowers, and it is also for lenders. Even during the moratorium period, in case any lender contravenes the provisions of moratorium, even there is a prescription of penalty and imprisonment for the lenders as well. So the moratorium is effective.
Can you just explain the moratorium?
No, moratorium,
for the people,
Alkaji, moratorium, because I am actually trying to understand, trying to give the background first. See, I will actually start the corporate insolvency resolution process, and there is a complete detail because we have enough time.
Right.
So this is the background that probably why I am confident that this process would be really fast. So there are provisions in this in the code. So this process is actually going to be fast, as everyone is trying to say. So the resolution plan also would be submitted by anyone. So this is also one of the in this IBC framework, even they have not left any scope for the judiciary to cause any delay. I can only simply say that there is a section 64 in this code which says that in case NCLT or NCLAT is supposed to pass an order within a specified time frame, and in case the NCLT or NCLAT is not able to pass that order within the specified date, they have prescribed a process for this. So the member in that case will record a note giving reasons that the order cannot be passed within those days. So the file will actually move to the president in the case of NCLT, and in the and before the chairman in the case of NCLAT, and the president and the chairman, they have power to extend that period, but not more than 10 days. So every time a member would actually require an additional time, there would be a note, there will be file will move to the president or the chairman, and they will actually have to sign it, and every time the extension cannot be more than 10 days. So I am saying this because I am just trying to say that this actually would be a fast track program. So otherwise, how many members would actually be able to afford that they can send the file every 10 days for in any case? So this is where I am confident that actually it will be a fast track movement. See, then I am also saying that there is a section 64(2) in this code which says that no injunction shall be granted in by any court, by any tribunal, including High Court, including Supreme Court. No injunction can be granted on the proceedings under this code. So this is also something which is carefully added into the code, because in the SURFACI Act we actually have faced injunctions, and those injunctions actually are presently taking in some cases even 10 years. I mean, there is another like section 231 which has been specifically added, which is saying that the bar of jurisdiction, no civil court will have any jurisdiction on any of the matter under this code. So this is also something which is specifically added in the code, so that there is no hurdles in future from any side of any in any process. Even section 63 says that then civil courts have no jurisdiction on the matter, where the NCLT or NCLAT has got the jurisdiction. So while I am saying this, I mean, section 238 also says that the provisions of this code to override all other laws. So this is what is the my belief, that this would definitely be a fast track program, and this will be a fast track resolution, and if not resolution, then fast track liquidation. The creditors in possession, the borrowers will not be in possession. So once the CIRP, which is corporate insolvency resolution process, starts, it will be very fast to conclude by two ways. One way to provide a resolution, the other way is to go for liquidation in case the company has got no model and no possibilities of revival.
I think you've explained very well why this law will actually function
why
and the
this law?
timelines will be followed.
So I was actually reading all this through, because earlier we suffered in SURFACI Act.
Yes.
We have seen, Alkaji, that in most of the cases there used to be a stay, and then you keep on tracking the court proceedings, and the court proceedings actually have taken longer than expected. So that time which the courts had actually given to the borrowers, that time was responsible for ineffectiveness of the SURFACI in various cases. So those time was enough with the borrowers to siphon off, to divert, and to milk the corporate and for their personal gains.
So the courts are also now time bound.
Now the courts are also time bound, and the most important provisions are where the members are also supposed to put a note, and they also, and the chairman and the president, they also have no power to extend beyond 10 days.
Correct.
This is something very, very important that all of us should understand. So this is the reason that this will be a fast track, and this is the reason that we expect complete success of this code. So today's topic would be like corporate insolvency resolution process. In short, we will say CIRP during our conversation. And before I say that, I should also appraise some of the participants who might be new for this code, that this code is the institutional framework in this code is that there is a Insolvency and Bankruptcy Board of India, which is a regulator in this case, and presently it is under the chairmanship of Dr. MS Sahu, who is actually implementing the law, insolvency and bankruptcy law in this country very, very efficiently and very, very quickly. Then we have the insolvency professional agencies, and one of the insolvency professional agencies is Insolvency Professional Agency of ICSI, Institute of Company Secretaries of India, and that agency is led by Mrs. Alka Kapoor. So she is also doing a wonderful job in spreading awareness, and they enroll members, and then the second enrollment goes to the board. Then we have insolvency professionals. I think so far more than 900 insolvency professionals have been enrolled. Then we have insolvency professional entities. The entities would be the qualified and registered insolvency professionals will get together and incorporate a private limited company or an LLP to take up the assignments under the Insolvency and Bankruptcy Code. Then there are information utilities for which the regulations have been notified, and we are expecting that the information utilities will start making applications before the board, and board will accept, and once the applications are accepted, the information utility will start their operations. We also understand that the registered valuers also going to be they also have to be regulated for this particular law, and presently the registered valuers are regulated by Institute of Valuers, but then let's see how this valuation profession also, maybe it is also regulated by IBBI in future. See, the adjudicating mechanism, like the court which is responsible for implementation of this law in this country, National Company Law Tribunal for companies and limited liability partnerships, and also for various other incorporated entities, like there are some societies which are actually incorporated. Then we have the appeal from NCLT orders would actually lie with the in National Company Law Appellate Tribunals for appeals, and after this will go to Supreme Court. So as far as the insolvency and bankruptcy law is concerned, the High Court is skipped in the entire judiciary, and this when it comes to the individuals and partnerships and HUF and trust and societies, then the jurisdiction will be debt recovery tribunals and debt recovery appellate tribunals. The law for individuals and partnerships and HUFs have not been notified so far because the regulations are under preparation. Once the regulations are notified, maybe another 3 or 4 months, that law will be implemented. However, when we say that the insolvency of individuals will be dealt by the DRTs, but any individual or any other entity which has given a guarantee for any company loan, in those cases the jurisdiction will be with the NCLT only. So the guarantors to corporate loans will face the insolvency applications before NCLT only. So the entire process, like under the Insolvency and Bankruptcy Code, is divided into 2 parts. Every application, once it is accepted, it will have to go through the 2 stages. One stage is corporate insolvency resolution process, CIRP, and the second stage is liquidation. So in case there is a resolution.
Welcome, Mr. Sanjay Grover. Friends, we also have Mr. Sanjay Grover, who is a renowned practicing company secretary and also insolvency professional registered with us, and he's handled 1 or 2 insolvency cases also. He has been appointed as IP in one of the case by one of the companies, and he's faced a lot of challenge in that case, which which he's going to share with us today. Welcome, Mr. Grover.
Thank you.
So welcome, Mr. Sanjay Grover, and I think should we continue?
We should,
okay.
please.
So see, we are on CIRP. So CIRP is a 2-stage process. First stage is the resolution process, and in case there is no resolution acceptable to the creditors, then it would go to liquidation. But there is a possibility of even the fast track resolution process also would be notified in a couple of days. Already the regulations are out for review. So in the case of fast track resolution process, the time would be reduced to half. So the time for the CIRP has been mandated by this code as 180 days. Total 180 days from the day the application has been accepted by the NCLT and the commencement of the CIRP is started. In few cases there may be a possibility of an extension, so they have actually made a provision that in case it is not possible to complete the process within 180 days, then there is a possibility of an extension which would be up to 90 days. But there is only one application which is possible, and in that one application the NCLT may extend for a 30 days, it may extend for 60 days or any part of it, or it may extend for 90 days. But there is no possibility of second application. NCLT will consider the pending work, and accordingly they will decide whether they need 30 days or 90 days. So I have already said that I trust that this 180 days period, or even if it is extended by another 1 or 2 months or 3 months, this would be complied with. This would be complied with because I have said that there are very strict moratorium clauses, there are very strict no injunction sections, there are very strict procedures which are actually supposed to be followed by the members of NCLT and the members of NCLAT. So all this, because of all this, we trust that this period of 180 days or as extended would be adhered to. So I think now let us coming to the detailing of the CIRP. See, I would actually answer one question, like who can initiate corporate insolvency resolution process? So the answer is number 1, all the financial creditors can initiate. Financial creditors include all the banks, financial institutions, NBFCs, private financiers, anyone who has given a loan to the company, any individual or any other company, any financial creditor. The only definition of the financial creditor is that they have given a loan. When they have given a loan means that the consideration should be time value of the money. The consideration of giving the money is the time value of the money. If anything has been given against time value of the money, that is a financial creditor. Then the second category of the person who can apply is the operational creditor, the person who has supplied goods or services to the company, corporate debtor. See, like when we say company or corporate debtor, it is the one and the same thing. See, the corporate, the operational creditor actually includes the workman, it also includes the employee of the company, and it is also including to the surprise of everyone in this industry, that it also includes central government and state government or any other local authority. So who can actually file this application? Any person who has given a loan to the company, any worker or any employee who has some dues, any person who has some dues, who has supplied some material or supplied some services to the company, or even the state government and central government or local authorities to recover their taxes. All these people can file their application. The first is categorized as financial creditor, the person who has supplied goods and services, the employee, workman, and the government departments, they have been categorized as operational creditor. And the last is company itself. When the company says that company feels that I am not able to service my debts, so the company can also file a resolution application. So this is there are three categories. I already said that there are two-stage process, and in the case the limit is, the only requirement for the time being is that the total debt should be more than 1 lakh of rupees. So it is 1 lakh at this moment, which might even be extended to 1 crore, and that would be any time by notification. Whenever the government says that this is being misused, the amount is being misused, so they can increase the amount. So when can the application be filed? So it is only, the only requirement is that there should be a default, and there is no requirement that the account has been categorized as NPA. The only requirement is that there is a default. So in the case of financial creditor, there is a loan, and there are terms and conditions, and if the loan is not being repaid as per the terms and conditions, it is a default. The default can be for a day, default can be for some of the installments, and default can be for few months or few years. So it is also applicable to all the existing cases, it is also applicable to all the existing agreements, and it is also applicable to the old cases. Unlike SARFAESI Act, when the action can be started in case the account has been classified as NPA, and also a 60 days notice is required to be given to the corporate debtor. Alka ji,
Yes.
one question which is regularly coming to me is, if it is only 1 lakh of rupees, suppose anyone can file an application, for example, against ONGC.
Correct.
Any of logistic person or any person actually can file an application against ONGC that I have raised an invoice for about 2 lakhs of rupees, and the company is not making me payment, and it was written in the invoice that the terms and conditions are 30 days. 30 days have passed. Now I am filing this application before the NCLT for initiating the insolvency process of ONGC. So what will happen to this kind of application? This is the people had been asking me this
Yes.
question.
I think you need to reply to this, because this is everyone's query, and
This is
some of
everyone's
these we
query.
received here also.
Yes, like I did not take the name of State Bank of India, I did not take the name of Life Insurance Corporation of India, because those, in any case, these banks and the NBFCs are not covered. But ONGC is covered, like IOC is covered, all the oil companies, all the 9 Ratnas are covered. So it has been very carefully drafted. The code has been very carefully drafted, and I would invite everyone's attention to section 65. Now section 65 says fraudulent or malicious initiation of proceedings. I would read it for everyone's understanding. If any person initiates the insolvency resolution process or liquidation proceedings fraudulently or with malicious intent for any purpose, now it is, I would repeat, for any purpose other than for the resolution of insolvency or liquidation, as the case may be. So let us analyze this. So there is only two purposes of the CIRP. There are only two purposes for the application. One purpose is resolution of insolvency, second is liquidation. If there are possibilities that somebody knows that this company has got no business and it should be liquidated, because otherwise in case we leave the company open in the market, they might even raise further loans and they might even trap more people in the debt. So, in case somebody takes an application before the NCLT and say that I have to recover my 2 lakhs of rupees, that is my objective. So, that person, one, that the application would be rejected, and the second is that NCLT may impose upon such person a penalty which shall not be less than rupees 1 lakh, but which may extend to 1 crore of rupees, depending upon the seriousness of that malicious intent. So, what should be the intent when we file the application? It should be the resolution of insolvency or liquidation. See, when I am saying this, everyone actually, whosoever has gone to all the judgments where the application has been accepted, most of the judges has also added 1 or 2 paragraphs in the judgment where they have said that there are other evidences that the company has defaulted. So, in the case of Uttam Galva Steel, the honorable judge has written this, that the company has already reported a loss of 1,550 crores in the last balance sheets. Shareholders are almost wiped out their own capital. There are other instances of default also. So, these are the reasons that the company needs a test of solvency. So, this corporate insolvency resolution process is also a test of solvency. So, this section has been carefully introduced in the act. So, this is where all the, so I actually would to my all professional colleagues that this aspect must be clarified, this must be checked before any application is filed. It is actually not possible that such an application can be filed and the time of the court is wasted. If in the arguments also some professionals say that the objective is recovery of my money, the member, the judge there can even say that it is malicious. So, the intention should be to test the solvency of the company. The intention cannot be to recover my own money. So, this is also like I have had meetings with various bankers, and till the time I started my presentation, everyone was feeling that this law has been made only to recover their dues. I said, as far as the backlog is concerned, there are, since you guys have a lot of backlogs of cases, so presently you might even understand this is for recovery of your old dues, and especially in those cases where SARFAESI is not giving any results. But this is see, when we actually tell them that this is the kind of objective, the objective is the resolution of insolvency, the objective is not recovery. See, let us understand exactly the in couple of words. Is there any question?
No, no. Questions are there. A lot of questions are there.
So, should we handle some of the questions, because it is already 4 o'clock.
Yeah, okay.
So, we can handle some of the questions.
Sure. No, Mr. Paul. I think the success of any webinar depends on the number of questions that we receive.
Yes, yes.
And I have a plethora of questions here. I don't think we will be able to answer all the questions, but let's take the important ones, and the rest, if they are equally important, we will share individually the responses of the faculty with the person concerned and also put them on our website. What significant role can a CS play under the Insolvency Code?
See, what
This
I
is,
understand is like I have full faith on the profession, because the curriculum of the profession also includes to a great extent company law, and all the company secretaries are supposed to be specializing in Companies Act. Number 2, they also have subjects like accounting, they also have subjects like normal business laws, and they also have subjects like writing minutes and the drafting of petitions. So, this is the kind of capability that I understand a qualified company secretary would have. So, let us understand, like starting with the petitions with the NCLT, this is all the company secretaries can do, and they are also authorized to appear before NCLT, number 1. Number 2, when a resolution process starts, like every meeting would have minutes, every meeting, and again the conducting a meeting of committee of creditors is also somebody who actually have been qualified and have been taught how to handle and convene meetings and how to record minutes. So these actually the minutes of committee of creditors are very important, and it is important in such a manner that 100% of the member attending the meeting will have to vote, and if one or two are not voting, then it will actually shift to e-voting. So as far as the company secretaries are concerned, they can actually play a very big role in this new profession in the country. They can become IPs. When they become IP, they can become IRP, they can become RP, and don't believe that one IRP or one RP is required in one case. There may be every member of the committee can bring their own RP. So you can be a consultant to another bank, because the RP or the IRP who is actually appointed in the case as RP, he cannot give consultation to other members of the committee. The other member of committee can actually will take consultation from other IPs. So this is a great opportunity for company secretaries, and I don't think that before this there is any other opportunity which has so far came in for this profession. So this is a very big opportunity, including when the NCLT is authorizing the company secretaries to appear before this court.
Absolutely, and I would further add to this that since the opportunity under the code is huge for professionals and especially the company secretaries, we would request them, all of you who have 10 years or more of experience, to pass the insolvency examination and to register as insolvency professionals and work as insolvency professionals, wherein there is a lot of recognition and also a lot of money involved in terms of the professional fees and other things. Achha, the next question is whether contingent liabilities, corporate guarantee, promissory note would be part of resolution plan.
See, as far as the resolution plan is concerned, one thing is very clear, that during the moratorium period, all the proceedings will be stayed, suspended. So for 180 days or extended period, the proceedings would be suspended. So if a contingent liability is appearing in the sides of the balance sheet, which is based on a particular proceedings, so those proceedings are all stayed. So during the resolution plan, it depends upon the opinion which is given by the legal fraternity who is handling those proceedings, that how much would be the liability in case the resolution is in case there is a resolution. However, in the case of liquidation, then of course, like there is whatever contingent liability might come out, that finally will become part of the claims. But then in case of liquidation, most of the proceedings will stand still. So the contingent liabilities as such will depend upon the stage, will depend upon the value behind this liability, and will depend upon the opinion of a legal person handling them.
Shall I also read out the name of the person who is making the query?
Yes, of course.
Yeah, this one was from Mr. Ajay Kumar Jain, and the next is from Mr. Hemant Kumar, which is very, very vital, but you will have to answer it in brief.
Yeah.
What is the difference between SARFAESI and IBC?
Now, in fact, like during this conversation for the last 30 minutes, in fact, I have talked about SARFAESI and I have also talked about IBC. Since as Alka ma'am has already appraised that we have an experience of handling 14,000 SARFAESI cases. So in SARFAESI cases, we have been facing a lot of hurdles from borrowers, hurdles from courts, and see, by the time we are able to take over the possession of the assets, one thing which is actually not good for the economy, that the business is always killed, because there is you see, even if the borrowers are using delaying tactics, they would actually be under the sword of uncertainty, that the business automatically gets killed. The the suppliers would lose confidence, so they would stop supplying. So the SARFAESI has been instrumental in killing the business, whereas in the Insolvency and Bankruptcy Code we are focusing on continuation of the business. So the primarily this is the advantage, although there was at a later stage there were amendments in the SARFAESI Act also that the banks can even transfer a running company, but those actually have not seen the practical light of the day. So not many cases actually could have been handled in such a manner that the running company is being transferred to somebody else.
Yeah, okay.
Although I have a complete presentation where I actually have categorized all the cases that we've handled in the last 14 years. We have handled 14,000 cases, and I have divided those cases into 6 categories, and for each category I have actually given the what was the difficulties in SARFAESI Act, what would be the difficulties under the SARFAESI Act, and what would be the position under the IBC. And then in each category of cases we finally have given our opinion that in this category what kind of action should have been initiated in the cases. So that is a separate presentation. I think this is a very large subject, whether SARFAESI or IBC, what should be invoked on a particular case. It depends on various facts and circumstances.
I think we can have a separate webinar on this issue.
Yeah, we can definitely have separate webinar on this.
Whether the IBC code is applicable for company incorporated outside India. Definition of person includes person resident outside India. Person includes company. So please clarify.
So this Indian this IBC is presently applicable in India. It is only applicable to the companies incorporated in India. It is also not applicable to the subsidiary companies of Indian companies incorporated overseas. So this is only applicable to the companies incorporated in India so far. It is not applicable to the companies incorporated outside India.
Yeah, this was from H.N. Sangeeta, and the next one is from Kanti Mohan Rustagi. What is a dispute? Is NCLT taking a different view of dispute in its decisions as envisaged by the committee?
See, one, I think this again I would refer to the judgment of Uttam Galva. In fact, I have these key highlights of that judgment with me. Justice B.S.V. Prakash Kumar dictated this order in NCLT Mumbai, and in this particular judgment, this particular question has been answered in detail, very clearly answered. So and it is actually not only this, it is also like there are various paragraphs which has been written on the word include, because the default the dispute includes, and whether it is inclusive or whether it is not inclusive, it is also been very clear. So the dispute in this manner is not the dispute can be for anything, like dispute can be for like the I never placed an order for these goods. This can also be a dispute. It was supplied without mandate. The goods supplied was not as per the quality I ordered for. The quantity supplied was lesser. It was supplied after my requirement, after the due date for the supply. So there can be various disputes, but then the IBC only says that the dispute would be accepted as a dispute if it is pending before a court or before an arbitration. If it is not pending before a court or an arbitration, then it will not be considered as a dispute. Now, I would say this dispute has to be, the court proceedings or arbitration proceedings has to start before the notice under section 8, because I have to give a 10 days notice to the 10 days notice before the issue of this notice, before the receipt of this notice. This proceedings has to be there as pending. In this case, in this Uttam Galva case, the corporate debtor, after they received notice from an operational creditor, very next day they filed a application of dispute before Bombay High Court. So then they replied that there is an existing dispute, but it was very clearly said So, I will read one small paragraph out of this order of Justice B.S.V. Prakash Kumar. A reply denying the claim despite default occurrence is clear. Does it mean that no application can be filed by an operational creditor even though the operational creditor makes the case of default occurrence? If that is so, it will be virtually ousting operational creditor filing any case under section 9. If this scenario emerges, then it will be nothing but throwing this law into dustbin. So, this is the kind of judgment which has come from this judgment. This is the kind of clarity which has come. Without any doubt, it says that in case I allow somebody to create dispute after the notice, then that means the operational creditors will be out of this law. Operational creditors will not have any remedy in this law. So, this is the clear mandate. So, there is the dispute is simple, but the occurrence of dispute and the timing of dispute, the timing of registration of dispute is different.
Mr. Goel, if I interrupt in between, have we seen any operational creditor being this thing been admitted? Only 2 cases have been admitted, most probably in NCLT across India.
See, one is the REI Agro has been accepted.
Yes.
REI Agro has been accepted. It was a case which was filed by an
REI,
employee,
yeah.
by an employee by the name of Mr. Joshi. It was before the NCLT Kolkata, and IRP was appointed. Then the only amount was 10 lakhs of rupees, which was an outstanding, very small amount.
Not even 10.
And you see, like since in this case the IRP was replaced by me, and we have received claims of 7,000 crores so far, and there are 22 financial institutions and banks which has given that money to this company. REI Agro.
There are a lot of fraud cases.
So far, see, the maximum claims that any company has received is REI Agro, and the maximum number of lenders like 22 financial institutions and banks. So, this is the kind of company which has gone into CIRP with an application from an employee who was only supposed to take 10 lakhs of rupees from the company. So, look at the understanding of the judges, but not only this. If you see the original order of Kolkata bench, it is also saying that the company is also defaulting on various accounts.
Yeah,
so, they have actually covered this section 65, so that nobody is filing malicious. It has also been covered, because so that nobody is filing a malicious application.
So, this other thing, SR project also is there.
Yes.
Which has been there.
And I think one more. There are 3 of them.
Something.
Yeah.
But that way, what I was coming on, that you said the operational creditors, honestly, there have not of operational creditors claims have been admitted till now.
But then you see, yesterday only I was looking at a judgment, and I was looking at an interim order, and that order, in fact, that order the NCLT said, since the company, the corporate debtor requested for 6 weeks time, and the applicant did not objected for this, and the NCLT actually allowed 6 weeks time for making payment. So, this was like the 14 days period in this case was compromised. So, this is what I understand is that this is a formative stage of the law, and not everyone actually understands the seriousness of it. Not everyone has actually read the complete law. So, these kind of errors will do happen, but that should not be considered as law. That should be considered as one error. So, in this case also, I actually would tell you, in the same Mumbai court, there was an order before, there was a judgment before, when it was said that the dispute is dispute. So, I actually will read for you. Like, see, there are a couple of paras that I actually feel like reading. If the companies are funded by creditors and mostly run on their money, can it be said that the shareholders of the company are the real owner or the creditors? Don't creditor have a right at least to realize their money before company is fully sunk?
Correct.
These are the kind of paragraphs in the judgment which I feel like complimenting. So, like going forward, see the objective in this case should be, whenever we actually file an application for CIRP, the objective should be to protect the interest of the creditors. So, this is a hugely accepted objective of CIRP, that it should protect the interest of the creditors. It should also empower the creditors to take the decision. It should also empower to apply their judgment whether the company should continue because the company's business is viable or not viable. And they should quickly liquidate those companies where the business is not viable and the shareholders are just continuing with this poor model of business because they are actually having some self-interest of their own. But these kind of company where there is no business model continuing, those companies should be liquidated as fast as possible. So, this is one of the objective. The other,
Sorry
Yes,
to
yes.
interrupt. This is basically the reason IBC is told as a creditor-based law rather
Yes.
than a debtor-based law.
this is definitely a creditor-based law. The power is totally shifting from the debtor to creditor, and the creditors have actually been given powers, which actually I will come back to resolution process, the resolution plan. Then the powers would actually be seen. This improves the rights of the creditors, and this otherwise also should improve the business environment. So, see then there is a process called when should the CIRP application should be filed. One, that it should not be filed on one or two defaults. It should be considered whether the company is regularly making defaults and whether the company is also making defaults on the other fronts. Then this kind of application should be made. It is also very important that the indications of default should not be only one indication, it should be many indications of the default, so that we actually need to test the solvency status of the company. Then see, there are possibilities of dispute with some of the genuine dispute with some of the suppliers of goods and services, but there is no pendency of suits in those cases. There is no pendency of arbitration proceedings in those cases. And in those cases, if somebody files an application to recover their own invoices, so then that means the NCLT would be very, very busy. And I am telling you, in most of the cases, when the intention of the applicant would be to recover the money or recover the invoices raised, that those applications would be rejected. So, whenever you file any application, you try to collect as many evidences of default as possible, and you make it a case that it is a case for testing the solvency of the corporate debtor, then only this will survive. Otherwise, the applications are not going to survive because of the section 65.
So, the relevant question what you just answered here is by Mr. Ramakrishna, saying that whether insolvency proceedings should be initiated only after exhausting civil remedies, that is arbitration or court proceedings, or disregarding the dispute resolution mechanism, insolvency proceedings can be brought up.
See, in case of let us understand the example of an operational creditor who have supplied goods or supplied services to any corporate debtor. In case he has complete documentation of providing getting the purchase order and also issuing an invoice, and also the terms and conditions of the payment are crystallized, then in case the company is solvent, the normal recovery proceedings in any court actually would result into recovery. And in case the company is not solvent, the company will definitely create hurdles and company will continuously fight all these cases. So, it will not be one case, then it will be many cases. So, I am not saying that they should actually try all the options available under other acts. It depends on the circumstances. It depends whether the company is defaulting on other fronts also or not. And if it is simply a case of one invoice and the company is saying that it is disputed, then it is better to go and settle with the company. Otherwise, like initiating the proceedings under section 8 and 9 probably might even revert as a penalty to you. So, the intention has to be the test of solvency. The intention cannot be recovery of one or two invoices. So, I am saying yes, in the case of solvent companies you should actually try the other options, but in the case of company which is regularly making defaults, you should actually initiate the proceedings even if you do not get anything, but then the society would save further loss, because these companies which are actually running on a bad business model, they would cause loss to the society, they would cause loss to the lenders, they would cause loss to the suppliers. So, these companies should actually be put to liquidation as fast as possible.
One or two more questions we will take, then we'll ask Mr. Sanjay Grover to
Yes.
share his experience. Sajay Kumar Jain, and this question many of people are asking, who will pay the fee of IRP? And I would add on to this that if the application is for a small amount, then who will pay the fee of insolvency resolution professional?
See, as far as the fee part is concerned, we have actually divided into 3 parts. Now, one part pertains to the first phase. First phase is preparation of application, submission of application, appearing before the NCLT in 1 or 2 hearings, and whether the application is getting rejected or it is accepted, that is one part of the fee which is supposed to be paid by the applicant. And this is also not forming part of CIRP cost. Then the second expenditure, immediate after this, the expenditure comes is the publication. Like the regulation has clarified it, that the publication cost will also not form part of the CIRP cost. However, the code says that the COC, Committee of Creditors, can approve this amount and can pay also. So it depends actually who has made the application. I mean, think of a situation that a particular financial creditor has made the application, and it is one person who has actually done this, whereas the mandate from other 22 is already there, so they can actually accept this, but this will not be form of the part of the CIRP cost. So one part of the fee is application till the acceptance, and the second is the publication cost. So mostly whenever a case comes to you, so you should actually ask for the fee for the first job and for the publication. So this means that you are appointed as IRP, so till now you have not spent anything. Now in case before you are appointed as an IRP, you must see whether the company has any assets or not. In case you are appointed as IRP for a company which has got no asset, then you will not be able to recover anything from the company. So who will pay your fee? So it is only in those cases where the company has not even 2 lakhs or 10 lakhs of rupees assets, then your fee is recovery of your fee is under risk. But in case any company has got assets to the extent of your fee, so that means that you will recover those assets, and either during CIRP or during liquidation, then you will recover your money. Yes, you might have to invest for some time. You might have to invest for during CIRP also, and you might have to invest even for liquidation. So the second part of the fees is as IRP, because the IRP is supposed to work very hard. IRP is collecting all the information, IRP is also getting all the claims, verification of the claims, collating all the claims, verification of documents of the claims, preparation of memorandum, information memorandum, getting the properties valuation, arriving at the liquidation value in some cases. So this is a one month and 40 days is a very hard working thing. So the second phase of the fees would be as an IRP, and this is a separate phase, because you never know whether somebody else replaces you or somebody else doesn't replace you. So for the next of the 5 months or less than 5 months or even extended period, you actually this is the third part of the fee, when you are actually acting as an RP. So the in case the resolution is a resolution plan is approved, then during the resolution implementation, in the resolution plan, if the committee of creditor accept you as a monitor, if the committee of creditor accept you as supervisor, then you can settle your fees, and that fees will be paid by the company during the course you provide services to that company. In case the company goes for liquidation, then the fees is based on the assets recovered and assets disbursed. So this is the kind of fee segments and stages, and this is the way we actually can take care of the fees.
Yeah, thank you for explaining it so well. But since we are short of time now, I think we'll first listen to Mr. Sanjay Grover, the experiences that he has faced, and very interesting ones during the course of his being an IRP. And subsequent to that, if we have the time, we'll take up the other questions. But let me tell you, since there are a lot of questions and very interesting ones, very important ones, what we'll do is we will frame their answers and put them on the website as FAQs, and we'll do that as soon as possible with the help of Mr. Anil and Mr. Sanjay Grover and other eminent persons who are in the knowledge of things. Yeah, Mr. Sanjay Grover.
Thank you, and sorry, Alka, I had to go to that Parliament Standing Committee on Finance. That's why I couldn't make it on time at 3 o'clock.
Yes, we understand.
Now, I was appointed as an IRP in one of the companies on 23rd of February 2017, and what we did, I gave a public notice same day and it appeared on the 25th of February. Now, when it came on 25th February, simultaneously the company's registered office was in Delhi, so we went to their registered office because the letters which we sent to the promoters or the corporate debtors, they came back. So we went to the registered office to give them the notices and all. It is a case of financial creditors, section 7, which has been as against section 8 and 9, which where hardly any thing has been admitted by NCLT, but section 7 definitely. So went to the registered office, they gave them the notice, but there was nobody in the registered office also. It was a very plain office where nobody except for the PN, nobody was there. But still we gave them the notice, took a notice and clicked some photographs. Now, from there I went to their plant, which is in Durg, Raipur, Chhattisgarh. That was 27th I reached there, and believe me, morning 27th onwards, I started receiving, 26th I reached there, 27th morning onwards, I started receiving calls from various people. It was not exactly calls, it was more of threats than calls. Aapko gaard denge, that, all those, I don't want to go into all the adjectives also. Now, what happens is, he had told, the promoters had told the workers over there that all your payments and also the contractors who were paying the wages for the workers, that your payment will be made by Mr. Sanjay Grover, the IRP. And they started saying, check leke aaiye. Check kaun sa leke aayenge? Check leke aaiye. Check. I have first, so I got a shock कि ये check इसलिए मांग रहे हैं. I have just started being an IRP and I was asking the people are asking me the checks. Then I could make out, yes, they are wanting their fees. I said, let me come over to the plant and then we'll see. Believe me, it was morning 11 we started, and it was about an hour or so from there, that place. We came to know from there, we sent some people. This is a financial creditor who was helping me out, and saw to it that there was many people, workers waiting outside for me. Me means an IRP, and we saw some threat. Again, calls were also there, and immediately we went to the police, local police. This is the difference, Mr. Goyal will agree with me. Now, in the courts, liquidation and all, the notices were going to the local police officials also, and OL office was being helped by that, ki Mr. So-and-so is coming to take over the plant and all. So please extend full help. Now, National Communal Tribunal, with due regard to the NCLT, it is not High Court. That makes a hell lot of a difference. Now, when we went to the IG, not the small person, IG over there, told him this is what the position is. By chance, he knew Mr. M.M. Kumar. So, it helped me. I said, this is the problem and how should we do? He said, okay, you take few people from me. He referred us to SP, who was some 2-3 kilometers away only. And SP sent some of the trusted people to the plant. Nothing. There was nobody over there except when I tried to enter the plant, they said, you are not allowed. I said, why? The police was also there, then also they were saying. when I अच्छा आप संजय ग्रोवर ना अपना ID proof दीजिए. I said okay, this is my ID proof. ये क्यों आ रहे हैं, ये क्यों आ रहे हैं, ये क्या है? आप सेक्शन 20 पढ़ लीजिए, उसमें बड़ा क्लियर लिखा हुआ है कि आई कैन अपॉइंट सम प्रोफेशनल्स टू हेल्प मी इन अंडरटेकिंग द वर्क. वो जानता तो कुछ था नहीं, बट फिर भी उसने पढ़ा थोड़ा सा, ही न्यू अ बिट लीगल, थोड़ा जानता था. देयर वाज नो प्रोमोटर इन द प्लांट, नो बॉडी. इस अंदर दे टुक मी टू द एडमिनिस्ट्रेटिव ब्लॉक विच वाज टोटली blank. There was nobody, no employee sitting over there. It was a working day. There was one HR head. He said कि नहीं, हमें promoters ने मना कर दिया कि आपको कोई help नहीं देनी, कोई support नहीं करना. Fair enough. Now, what happened? We moved out because waited for half an hour, clicked some photographs, and when we moved out of the administrative block, hi, Sanjay Grover, hi, all those things. That reminded me some things which happened 2-3 years back also in the institute. So, what I'm trying to say, a lot of problems were there. Now, we moved out without any scratch. But what happened? Next we thought कि चलो अब next day सुबह हम जाके first को हम दिल्ली आ गए, and we thought कि हम 19(2) की application डाल देते हैं. 19(2) talks about if you have been obstructed by the corporate debtor, you can come to us and say that we have been obstructed and we'll pass necessary order. But that very minute, I mean, sometime later we came to know they have filed an appeal in NCLAT. So I didn't file anything. Now, we went to NCLAT, it was heard, and they started saying that we are a solvent company, there's no problem, we will pay, we are paying. It so happened that the chairman of the NCLAT, Mr. Majumdar, took that phrase and he said, why are you not paying then? You have confirmed that this is the amount due, they are confirming that we are the solvent company, why are you not paying? The council agreed to pay certain amount and balance amount within March. He said, no, that's not the question, you have to pay it fast. He said, please stop the IBC. The code, IRP should be removed and the process should be so that we can come back. I said, fine, let's see what happens. They went, and then we, in fact, in between I forgot certain thing. When we went to Raipur, we met the bankers of the company. We had sent notices to the bankers that I have been appointed as an IRP and this thing has to be operated by the IRP now. When we went to the bankers, they said, what is IBC? First thing. That is very surprising. Or maybe it's too early because December it started and we were there in March, February, and said, okay. I had in between also checked the MCA portal about the company and all. The last balance sheet they had filed was 2015 March. When we went to the bank, met the DGM and all, they said, नहीं company तो बिल्कुल ठीक है, ये है, कोई problem नहीं आ रही. मैंने कहा कब तक उन्होंने फाइल किए हुए हैं अपने रिकॉर्ड्स वगैरह. They said March 16 तक. I said, can you share with me March 16 because when MCA portal is saying March 15, so how can you say March 16? Fair enough. They came out, उनको बोला कि लेके आइए ज़रा. They brought out the income tax return which the company had filed. That is the level of education the bankers have. I mean, it has to be the company law procedures which are required for filing your annual accounts and all, and not the income tax. I said, okay, this is not the one. We are looking at the section 129 and the compliance and of all that. Now, over here, when NCLT had passed an order that you have to pay a certain amount, they agreed to pay a particular amount and they requested for IBC to be stopped. Mr. NCLT didn't agree to that. they said, okay, we are paying the full amount. That was, I think, 6th of March. They paid the full amount of 17-18 crores. By that time, we had given a public notice also, and public notice is very clear that whatever claims you have of the creditors, it has to come. After paying the full amount, they requested that thing should be stopped, the IBC process. We said, since we have already given a public notice, so that process cannot be stopped, because it is a statutory requirement that claims have to come, and up to that time we cannot stop. By 8th, we had received 4 claims, and all 4 were operational creditors. 7th, we went again to the plant, and again with the help of police only, we tried to go, and same problem. So, as an IRP, that may be one challenge, because the corporate debtor will or may not like to cooperate with the financial creditor or IRP. Now, it came to NCLT, because the NCLT had said that since the entire amount has been paid, so I am removing it, and let it go to the NCLT now, where it came from. Now, NCLT was listed on the 9th, so 7th I again went to Raipur, again same problem, obstruction and all. 8th we came to Delhi and filed a section 19(2) obstruction petition, which was listed on 9th only, and the principal bench very clearly told the counsel of the corporate debtor that please tell your client, if they are not cooperating with the financial creditor, they will be behind the bar. They said, fine sir, we are paying the entire amount, by evening we will be giving you the full DDs. And if they want to come, they are most welcome. We will not be having any obstruction whatsoever. But since we are making the full DDs, what should we do? Full DDs, one is the financial credit was totally cleared. The operational creditors, they objected that these operational creditors are those who are from the same family of the financial creditors. Now, the NCLT said that what should we do? I rather told them ki, let me be allowed to go to the plant and then see whether these creditors, operational creditors, are the actual real creditors or not. Now, here where the thing happened, that NCLT said that now, since you are not allowing us, not allowing the IRP, so you have to make the payment or allow the IRP. They wanted the IBC code to be finished, stopped here and then, and so they said, okay, we will be making the entire payment. Now, next thing came was the fees of the IRP. They said, I think it's 33 of ICSI IPA, which says that the fee has to be paid by the applicant. Now, over here, they objected that fees has to be paid by the applicant, which is the financial creditor. Why should we pay? I said, okay, kindly go further. It's very clearly mentioned that committee of creditors will decide how much fees has to be paid. Am I right on that?
Correct.
Yeah.
But committee of creditors was formed in this case. It was not constituted
so
only.
it was 20th day,
Yes.
19th day.
See, but I think Mr. Grover, in this case, first part is that the fee for the application and the fee for the publication has to be given by the applicant. So, it is not supposed to be claimed from the corporate debtor. Number 2, in case you have continued as IRP for some few number of days, then it has to be presented in a COC meeting, and the COC meeting will decide, unless it is decided between you and the applicant. Although the applicant, even if the applicant decides any fee, it has to be ratified by COC, and COC will go by the rationality. They will not go by whatever has been agreed between you and the applicant. So, the COC in this case was not formed, it was not constituted. So, in this case, probably, since the applicant has recovered its complete dues, it is the responsibility of the applicant to pay money for your efforts, for your professional time. I do not think this money actually ever it was required to be paid. In the code also it is not required to be paid by COC, because the COC was never formed and the case actually came out. The biggest beneficiary in this case is the corporate operational creditor. See, as far as the taking possessions of the concern, I actually have answered these questions many times during the seminars at banks, during the conference room discussions with senior bankers. They have always asked me a question that you as a standalone person, how would you go and take the custody of some company where 2000 workers are working. So, I had always been giving one answer. I said that the first step which is to be taken by the IRP is write letter to all the financial institutions and banks where the company is maintaining the bank account, and the very first efforts would be to take the control on the bank accounts of the company. So, this is the lifeline of any company, the bank account.
The first day,
so, when
23rd, 24th only.
So, when the bank accounts are in your custody, the second thing that you should do for your own protection is go and take the videographs and photographs of all the places where the assets and stocks are lying. And the third is there is no panic. The third is like have meetings with the borrowers, have meetings with the management and try to tell them, try to observe from their discussions whether they are solvent or insolvent. In case they are insolvent, in case they are having stress, then it should be told to them that this is the best scenario for your help. Then they should be told that it is the best scenario that you might even get a relief from the operational creditors in your balance sheet. You might even get relief from the government taxes which is actually troubling you in this not only moratorium period, even forever. This particular process can give a relief to the corporate debtor, and the corporate debtor may have to, in case of a resolution plan. I am giving you an example, although I have a lot more to say on CIRP, since the time that we said it is only up to 5 o'clock.
Yes.
So,
I think we will have another session on this.
We will actually have another session because the CIRP is just initiated, it is just started, because I can actually have about 2 hours on CIRP because I need to talk about the application, the procedures in the application, the manners in which will be accepted, the manner in which will be rejected, and I also have the kind of information that will be prepared as an information memorandum. I also have a very large presentation on the resolution plan. What are the possibilities of resolution plan, what are the mandatory contents of the resolution plan, see how the corporate debtor would get benefited out of it, what is the dissenting creditor, what is the like amount payable to the operational creditor. So, as far as the CIRP is concerned, CIRP is a very large. I would only request Alka ji that this CIRP session cannot be considered as concluded. We actually need to have.
No, we'll have another one.
We'll
the
have
next
another
session
one.
We'll have on this.
If this will have another
yes.
2 hours, then only we'll be able to conclude. I am not saying including liquidation. I am only saying
That is separate.
That is separate.
That is
So,
separate.
CIRP, because the resolution plan itself has got lot many things to be discussed. Something which I have seen that hardly there is a clarity on what would be a resolution plan, what are the possibilities in resolution plan, what are the section says, and what are the expansions of the section that you can add out of your experience. So, this is one that we actually would like to say that the CIRP is not concluded. As far as Mr. Sanjay Grover's difficulty is concerned, I will share my own experience, because under SARFAESI Act, my company has actually taken more than 2000 physical possessions of the assets of the companies, including the larger assets and smaller companies. So, we have taken custody of all the bigger assets, but in those cases we normally take the local authorities order and also take police along with this. Not only police, we also take along, in depending upon the size of the factory, whenever we go we normally take our own 1-2 car load or even bus load of our security, private security personnel, because the moment you take the custody you actually have to place your own security guards there. So, those security guards, they travel along with us whenever we go for taking the custody of assets of a company. So, this is what we have been doing under the SARFAESI Act also. It's one kind of difficulty that Mr. Sanjay Grover has faced is primarily because of one reason, that the company was solvent and the company actually could not understand what has happened with them. They never expected that this kind of law has come into this country.
They never wanted IRP to take over the
they never
the
wanted.
company.
So in this case, the moratorium, information memorandum, resolution plan, everything is actually supposed to be dealt with. So and then we'll have a next session. In the meantime, we still have 10 minutes. We can have some of the questions, or you would like to conclude?
Mr. Grover, you would like to share something else?
No, basically this is there is one more thing which is happening of late. I'm not sharing my personal thing because that was over. It was not because of me as IRP. It is more because of the IBC that this thing happened. Because of the IBC, the corporate director never wants that he should be removed as a managing director of the company. The board is totally finished. The bankers are informed. That is the basic thing why it finished within 21 days. We were able to recover 28 crores, which is nothing in your experience.
I definitely, I understand. One thing is very, very clear, that taking custody of the assets of the company is not really required. Physical custody is not required. See, what I am trying to say is, if a company is operating, it is the prime duty of the IRP to let the company continue its operations.
Promoters, I know. I told them very clearly the operation should continue. It's very clearly written that going concern thing, everything we told them. But the promoters were not there. Only the few managers were there. Nothing more than that. There's another case which is happening very recently. Of course, it's not where I am involved. That is AMR case. If you've seen Nikhil Mehta versus AMR, where assured return was assured. If you look at many companies, many people have this problem.
That was a dispute regarding whether it is an operational creditor or it's a financial creditor.
So whether it is
or it's none of it. So, like, see, somebody is asking a question: why the unpaid dividend? Why it should not be considered as an operational creditor or a financial creditor? So, like, I also have answered that the unpaid dividend of any shareholder, even after declaration of dividend, in case it is unpaid, it is not covered either under financial creditor or under operational creditor. So, that particular debt is not considered as debt, which is considered a debt. It's section 7, 8, 9 or 10 is not applicable.
So, I think that has gone to NCLT, that AMR case, and I think is listed for 24th. That is very important judgment because there will be many people who will be coming after that. That I was also given assurance that this much amount will be paid to me directly every month. So, that thing will be decided on the 24th whether the NCLT agrees to that or not.
So, let us take
Okay.
Alka ji.
Yeah, one question is by Mr. Prakash Pandya, can resolution professional who is practicing professional, can he file the application under section 7 or 9 or 10 of IBC and appear before NCLT? And in the same proceedings, whether he can give consent to act as interim resolution professional?
No.
I think there is a decided case
on
this.
The cases has already been decided by various benches.
Yes.
That when a person is arguing whether the application should be accepted or application should not be accepted, so it is considered as clash of interest, because if the same person is appointed as IRP or RP, so there is a clash of interest, because even if it is a case for acceptance or not acceptance, if a same person is proposed as IRP, so it is a clash of interest. He will not look at the merits of the case, he will only look at that it should be accepted, because it is his own benefit in case it is getting accepted. So, because of this clash of interest, the benches are saying that it should not be, the same person should not be representing at the time of the filing of application and at the time of hearing for whether it should be accepted or it should be rejected. However, in all subsequent hearings in the same case, where he would be reporting, where he would be actually making an application under section 19, he would actually be making the application before the NCLT for various other reasons. He would actually be making application for preferential transactions, or he would be actually making an application. So, various applications he can represent the company before the NCLT, because in those cases, in those matters, there will not be any clash of interest.
Because in that case, they replaced Mr. X with Mr. Y.
Yes.
So, that is very important.
Yeah. So, what are the other questions, or we would like to?
I think we are nearing the time. What I would like to inform the members and other professionals is with regard to the publications that we brought out for their benefit. One is the Insolvency and Bankruptcy Code 2016 with rules and regulations, and yesterday only we got out this updated edition of this publication, which has complete regulations, including the regulations on information utilities as well.
The information
Okay,
is
this
Yeah,
is the
we've
new one.
included information utilities and the latest liquidation
that's very
regulations
good.
which have come. And the second one is Interim Resolution Professional, a handbook. This contains details about what an IRP within the 30 days is supposed to do, and it's very important for insolvency resolution professionals to begin their task. These are available for sale with the institute, and you can purchase them by sending, this book is only of cost rupees 200, while this is for 550, and you can purchase them from the institute's headquarters or by sending a demand draft. And how to obtain it, we have given the details on our website. Secondly, as ICSI IPA, we have dedicated website wherein we upload all the
Judgments.
knowledge developments, and we share the knowledge training programs, the videos, the questions, everything is there. FAQs all are uploaded there. You can go through the website. As part of our knowledge sharing initiative, we are also planning to organize workshops for the insolvency resolution professionals, which will be intensive workshops, and shortly we will announce these. Apart from that, we are regularly issuing weekly knowledge repository, that is a weekly update on the happenings in the new legislative area. I am sure many of you would be getting the same. We are circulating it to all our members and to all the insolvency professionals registered with us. Besides that, we are maintaining the data, regularly supporting the IBBI, which is our main task, to support the Insolvency and Bankruptcy Board of India in their various initiatives. And we are shortly going to constitute a committee of experts through which we will be resolving all your queries and questions which are arising in the implementation of the new code. Any other suggestions, you're most welcome to send to us, and the email IDs are there on the website. With that, I think the time is over. These questions, which are very relevant, we will take in the next program and in the next webinar, and I request Mr. Anil to be there in the next
No, I would
webinar.
like to continue
Yes,
the
and
discussion.
continue your
And since I
discussion.
tried to elaborate, so it actually extended the time. Even otherwise, also it is not a subject which can be handled in 2 hours, because CIRP is
Yes.
almost half the code.
Yeah,
Correct.
actually.
It is
That's
half
right.
the code, because the
That's
next
right.
part is only
So
liquidation.
maybe 1 or 2, whatever webinars are required,
Yes,
we
yes.
will hold those. And the questions also, as I mentioned, we will reply to these questions through our website as well. Thank you, sir.
Thank you very
anything you want
much.
to say?
Thank you very much. I would like to say again, convey my thanks to ICSI, IPA of ICSI, Mrs. Alka Kapoor, and I am actually very happy to have a colleague with me now,
Always,
Mr.
always.
Sanjay Grover.
My
He
pleasure.
actually shared his experience, and I am telling you that this kind of experience would be there in the life of an IRP, and be ready for these experiences. We have seen this for the last 13 years under SARFAESI Act. Initially we thought it is difficult, but when law is in your hand, when law is in your side, there is nothing to fear. It is only the guts. It doesn't require any muscles. It only requires your guts, and guts only comes to you when you are on the right side of the law, when you have your ethical practices. The only objective should be let the business continue. In case any IRP would try to kill the business, that is not the objective of IBC.
Never
The objective is to let the business continue and find a solution, find a resolution. In case resolution is not available because of the business model, then let the company go to liquidation as fast as possible, so that no other person would sink his money. With this, I take this opportunity to thank the institute and thank everyone, thank the participant who have been listening to us patiently, and thank you very much.
My thanks also to everyone who is part of this webinar, and thanks to Alka.
Thank you, Mr. Grover, and thank you, Mr. Anil. Thanks to all.